Well, good evening, everyone, and welcome to the third in the series of 3 sessions that Peter, Jorro and I are doing with a view to publicising our new book, the second edition of our manual on immigration appeals and other remedies, a book that doesn't only deal with appeals, it deals with JRs and administrative review as well. So far, we've looked in detail at various aspects of upper tribunal procedures. We had a whole session on JR and now, in our third and final session, we're going to discuss one of the most topical issues of the last year, an area which has completely changed in practice, which is the sphere of remote hearings. And the topics that we're going to aim to cover between us in this session will be Pete's going to deal with the current FTT directions and how they're going to work. Then also he'll talk about which appeals are most likely to be suitable for remote hearings or not. And Pete's other topic in due course will be the High Court litigation about whether the Upper Tribunal was right, spoiler alert, it wasn't, to abolish oral error of law hearings back in summer 2020. And where the topics I'm going to cover in due course are going to be evidence from abroad in remote hearings, practical points about preparing for the remote hearing, preparing both your client and your state of mind, and also I'm going to look at out-of-country deport, which of course were always the sort of canary in the coal mine in terms of seeing how remote hearings might work in practice. So doubtless you know both of us there. Peter Jorro, I'm going to just give a brief introduction, though he doesn't really need one. Obviously, Pete's been at Garden Court for a very significant period, one of the more senior members of the immigration team, enormous experience of litigation at every level, specialising, I suppose, though he does everything in refugee and commercial immigration stuff more than anything else. On that note, I'm going to hand over then to Peter Jorro. Thanks.
Yes, thank you very much, Mark. Thanks very much. So can everyone see me? Yeah, I can still see Mark. Okay. Well, assuming everyone can see me, what we're going to now be talking about today are remote hearings, and in particular from chapter 7 of our book. Here we are, chapter 7. What we have there is a whole chapter specifically dedicated to the subject of remote hearings. Now, so in many ways, the COVID pandemic and the consequent lockdowns have massively speeded up a project that's been in its place for a number of years and developing. We've had remote hearings for bail hearings for a long time now. September 2016, Ministry of Justice announced intention to introduce fully virtual hearings. And the COVID disaster coming in 2020 prompted a whole change of process and the way things were being done by the tribunal in our particular area of law. And with the book, chapter 7, we talk about the development of remote hearings and cross-refer to other parts of the book, and in particular to directions for the setting off and appeal lodging. And in that context, what we're going to look at briefly for now is the First Tier Tribunal's user guide from January 2021. And this is all based on, in particular, the development since June of 2020 and the new way of lodging appeals online. And in particular, this business now of the MyHMCTS method of lodging appeals for represented appellants. That's the proper way of doing it. And one of the features of doing it that way is that you don't need the grounds of appeal. And we'll come to the particular reason for that why in a bit. But the current situation is that all appeals with represented appellants should be lodged under the MyHMCTS system, except for the following ones: appeals under the Immigration Citizens' Rights Appeals, EU Exit Regulations 2020. We discussed those in some detail, not obviously the most interesting subject in some ways, but we discussed those in some detail in our first session back in April. Similarly, you wouldn't have it done if the appellant is outside the UK or is in detention, or if the appeal is not represented by a person qualified under Section 84 of the 99 Act, or if the appellant's appeal is linked to another appeal, particularly one that's already been lodged. Now, with other appeals, where particularly unrepresented appellants, they can still appeal online or they can appeal using post or fax. But the important thing really about all this is that the tribunal will make decisions on whether or not to have a face-to-face hearing in court, a hybrid hearing where often the judge won't be in court, but sometimes the appellant and representative will be, an odd way of doing it in some ways you might think, but that's a hybrid hearing, or a fully remote hearing, in theory by telephone or by video links, and there are various methods of video link. In my experience, the video link is much more common than telephone. Now, one of the ways in which this is all developed, and in a way which can be certainly very beneficial to appellants, is that instead of simply an appeal being lodged with brief grounds of appeal and then a hearing being listed soon after, there's now a whole process, whether it be done by live hearings or for the remote hearings, where the tribunal sets out a timetable. And the current timetable is that once the appeal has been lodged on the system, online or by fax or post, then the respondent, Home Office, is directed to produce their bundle, which should include the refusal letter and all the information. Often the Home Office don't do this, they choose what information they'll put in, but in theory it should be all the documentary evidence put to the Home Office that was present before them in the decision-making process. And that will be done in theory within 14 days. Once that's been done, then it's over to the appellant side to produce a skeleton argument or an explanation of case. And this is supposed to be done within 28 days of the respondent's bundle being provided, or 42 days after the notice of appeal, whichever is later. So that's beneficial, as it were, to appellants. If the Home Office delay putting in their bundle, then you've still got the 28 days to put in your additional bundle and the skeleton argument. And this is actually something that can really work quite well for appellants, because with a well-crafted skeleton argument, one that actually engages with the reasons for refusal letter, and with further evidence that can be presented in an appellant's bundle that contains matters that weren't in the respondent's bundle, one can develop a very detailed attack on the refusal reasons, with the result that that then goes to the Home Office as well as to the court. And then the Home Office is then obliged within 14 days of receiving it, as per the directions, to undertake a meaningful review. Now, this is something that long before the COVID pandemic, the tribunal was trying to encourage: a pre-hearing review by the Home Office in light of the case presented in the skeleton argument and appellant's bundle, rather than this business of people turning up to court with a listing and the Home Office then conceding on the day, which is something that used to happen in the past and caused various issues. Not obviously one of the issues being the costs involved. But now the system is a standard way. So basically all appeals now in the FTT are working on this basis. And this in a sense is a sort of correlated with the COVID crisis and remote hearings, as sort of in a development that's gone alongside with it. And in these meaningful reviews, the Home Office are told that they have to actually engage with the argument and the evidence produced by the appellant side, rather than simply sticking their heels in. Because obviously, particularly in asylum cases, refusals will often be on credibility grounds, with much invocation of Tanvir Ahmed in terms of saying why it is that any evidence that the appellants produced at the earlier stage is not to be given any weight, or given only little weight, whatever that really means. So with a detailed appellant skeleton argument with evidence that can back it up. So for example, where the Home Office refusal letter has engaged with evidence produced by the appellant in the most minimal way, with lots of references to being it secondhand or scrappy or so forth, it's always a good idea to actually take that on board. And for example, if someone's producing evidence from an individual and the Home Office say, well, we got no way of knowing who this is, produce as much evidence as you can about the individual. If they're a senior party official, for example, in the appellant's party that the asylum claim is based on, then maybe something from the internet. Contact details, provide the Home Office with the possibility at least of contacting the letter writer, the statement writer. And this can then all be presented to the Home Office in such a way that it sort of narrows their angles for making adverse credibility case in the appeal hearing itself. But as I say, under this new system, which should be used as much as it possibly can be, a well-crafted skeleton argument with proper evidence that goes particularly to challenging the issues that the Home Office have come up with in their stated reasons for refusal can have a highly beneficial effect in terms of getting the Home Office to concede the appeal. And where the Home Office don't concede the appeal, at least it then puts them in the back foot, because at an early stage, their basis for refusal has been challenged. So in other words, it's no good for the Home Office then to say to the judge a month or two later that they didn't have a chance to contact such and such a witness or make any such research into the matter, because it was all there some time before. Obviously, as an aside on that, from counsel's point of view, it does have the slightly irritating effect is that you end up doing the case twice, because you prepared the skeleton argument and then sometimes many months later there's a hearing and you think, which case was this? But nevertheless, if you've done your own skeleton argument well, then you'll be able to read it and then you'll remember what the case was all about. So as I say, I think that's a particularly important point. The current directions are quite specific about how it works in terms of people putting in their evidence late. And they say that there should be a sort of judge dealing with the case should do an admissibility decision on any evidence that's provided late beyond the timetable. A party may not rely on the material which has not been provided. And then furthermore, where the system is supposed to be on this My HMCTS one, what the directions then say is that the material should be ruled uploaded onto the system. And they should stand the appeal down in order to do that, which can of course cause certain negative effects. The rules for unrepresented appellants, or those not using the HMCTS system, are broadly the same in terms of the timetabling and the provision of late evidence, but you're more likely then to get a case management listing. In these rules, they do specifically distinguish between pre-hearing reviews and case management on the basis of saying that one, that is, a pre-hearing review is where the judge or the tribunal caseworker considers on the basis of the information and documents filed that the appeal is ready to be listed for a hearing, whereas the CMRH is a short hearing where the judge together with the appellant or representatives and the Home Office get the appeal ready for final hearing. And those are sometimes done under this system by telephone means. So, as I say, this new system that's developed with in some ways in correlation with the COVID pandemic does definitely have advantages for appellants if the Home Office can be persuaded to re-look at the decision in light of the new evidence and the arguments. And so that's very important to not miss out on that. Now, if I could turn then to another topic, which is this business of when a case is suitable for an appeal for remote hearing. And our book at chapter 7 goes through this in some detail. Now, the overriding criteria is whether the case can be dealt with fairly and justly. That's the key overriding objective, fairly and justly, by way of a remote hearing rather than an in-person hearing. And certainly in the early days, judges were generally taking a view which was that they would only have remote hearings where all the parties agreed. And that certainly is obviously a factor of great importance, but it's not the only factor. In other words, it's not a system of veto where either party can veto it being dealt with remotely. And that's an important point there in terms of developing the issues. So it's a highly fact-sensitive matter, and it's ultimately for the judge determining the appeal to decide whether the case goes remotely or not. And in terms of challenging a decision that the hearing should be dealt with remotely, where the result goes against you after the hearing, is the standard principle of a challenge on fairness grounds, i.e. there's nothing to do with Wednesbury reasonableness or so forth. It's simply whether or not the higher level judge took the view that the decision to go ahead remotely in the case of resistance to it was in fact fair. Now, we have a particular paragraph 7.9 in the book, a set of factors that would decide whether or not a hearing is appropriate to be held remotely. There's Court of Appeal case law, which is referenced in the book, basing various factors which are relevant. So the importance and nature, so we have those factors listed. The importance and nature of the issue to be determined is the outcome that is sought in interim or final order. Whether there's a special need for urgency, or whether the decision could await a later hearing without causing significant disadvantage, whether the parties are legally represented, the ability or otherwise of any lay party to engage with and follow remote hearings meaningfully. So obviously there are some people who simply, for all sorts of reasons, education, technology availability and so forth, are simply not going to be able to deal with a remote hearing, and then the whole thing becomes a somewhat pointless exercise. And obviously whether evidence is to be heard or whether the case can proceed on the basis of submissions only. A submissions only case is inherently going to be more suitable for remote hearing. The source of the evidence to be adduced and assimilated, for example, whether the evidence is written or oral, given by professional lay witnesses, uncontested, or factual evidence. The scope and scale of the proposed hearing. how long the hearing is expected to last. There's certainly no doubt about it that you see the screenshot now is showing some of these factors from our paragraph 7.9. We've all experienced, I'm sure, these remote hearings where things start going wrong with the tech. And this can be a very major drain, you know, in terms of things taking ages and ages, whereas with a live hearing, none of that would have happened. Against that, on the other hand, remote hearings can have major advantages in terms of people not having to travel and so forth, you know, so there can be big advantages to appellants as well. You know, the business of remote hearings obviously links in with the advantages of oral advocacy and the ability of witnesses to give their evidence. And there's all sorts of pros and cons of remote hearings there. Sometimes there's these problems with witnesses appearing like little postage stamps in a way that I can see myself on this screen now. And other times, if you can make the screen better, it can actually be easier for the judge to see the witnesses than it can sometimes be in court. So all these factors, in a sense, do link into the level of the tech and the advantages. And one might, as one might expect, as time goes by, and as people, particularly the lawyers and the judges, get more used to the technology, there's a lot of scope and advantage potentially for remote hearings. And then there's the other business, of course, whereby during the height of the pandemic and the lockdown, on the whole, what was going on is that everyone involved in the hearing was in different rooms, different places all over London or around the country, or indeed abroad. We're going to talk about witnesses from abroad in a bit. As the pandemic comes to a close, we're going to have more likely hearings where they'll carry on doing them remotely, but each party will be in one building. So, for example, in our business, you may very well be in a solicitor's office or counsel's chamber. And then there'll be issues, obviously, to consider about how you manage witnesses. Because one of the big, the great things of face-to-face hearings in courts is that the judge and their clerks can make sure that witnesses who are going to give evidence can be kept outside of the hearing room. Mark, I remember, had quite a funny story about one judge who thought he had spotted witness interference going on with an interpreter and went jumping off his seat to go and engage in the corridor. Now, that's almost impossible for judges to do if you're going to be doing remote hearings where the witnesses are all in the solicitor's office. So there's issues there involved with trust and so forth. On the other hand, the other big problem for remote hearings, often where the counsel and the witnesses are in different places, is how you can contact and communicate with your witnesses when you're actually making the hearing. And one suggestion we put in the book is WhatsApp groups. If you have a WhatsApp group with the counsel, solicitor and witnesses and so forth, then as long as it's all done with proper probity, that's a way in which you can communicate in a proper way without having to go through in front of the judge and so forth in the Home Office side. So these are all factors in terms of determining remote hearings and how they're going to work. Now, Mark's now going to talk about some of the practicalities of it, and in particular about witness evidence from abroad. Thanks.
Great. So, really interesting stuff there about what is a intensely practical topic, but is very much one of the biggest issues of the day in terms of what we're dealing with. So, evidence from abroad, giving evidence from abroad. How does that work? And so there is a case that's happily sat there for a few years called NARE, N-A-R-E, Upper Tribunal Decision, and whose importance perhaps was seen as having lapsed in the emergency era of remote hearings. And so what we've had over in recent times, obviously the last 18 months, there's been a tendency to actually get on with it. The attitude has been to get on with it more than anything else. And perhaps the NARE enjoinders have been somewhat forgotten. I think the Upper Tribunal are presently sitting on a decision, in fact, whereby they're going to be giving updating ruling on the NARE issues. Anyway, so the point made in NARE, essentially, as I say, N-A-R-E, NARE, is that the normal courtroom model is supposed to be adhered to wherever possible. And this is particularly important that when a witness's evidence is being compared to other evidence in a case, be it documentary or other oral evidence, it's important that they don't lose out simply on the basis that their evidence is being given in another form than you might have expected. The next point is that evidence should be formal. And so in the era of NARE, it was said that people should be going to a formal setting, e.g. a court or a British High Commission or abroad in order for the necessary formality to be seen and supervised. And it was for the party making those arrangements to basically make everything happen. And it's fair to say, I suppose, pre-COVID era, that the tribunal wasn't enormously receptive to evidence being given from abroad, what with it being quite a lot of fuss for not an enormously high return sometimes. Other points made by the NARE tribunal was that where you're having evidence given from abroad, if possible, an attempt should be made to agree it. Again, that's not historically been the culture of the first tier tribunal, though no doubt the directions, the more heavily managed directions and the advanced Girton arguments give more scope for that. So, rather than having to call a witness who's abroad, it may be possible to get the Home Office to agree that their evidence is not disputed, in which case it can just go in by witness statement or possibly letter. Sworn witness statement, always better. Also, there should be a timely application for this, to call a witness from abroad in order that the tribunal can case manage it in the right way. There should be a formal, as I've said, there should be a formal setting. And the tribunal warns that it's concerned in NARE that if these strictures are not followed up, there is a danger of losing control over things and undue informality. I mean, I imagine that we've all participated in tribunal hearings in the last 18 months where things have ended up out of necessity being a little less formal than might otherwise have been the case. But one of the most interesting features of NARE is the fact that the tribunal point out that, as is found in the CPR, in the White Book, the expectation is, where witnesses giving evidence from abroad, that you have checked it, that it's okay with the foreign authorities, who might have diplomatic objections or who might have legal objections to it going ahead. And it transpires that there is quite a rich tapestry of considerations on this. One interesting point is that when we were a member of the European Union had a directive about giving evidence from abroad, which meant that everyone automatically consented to evidence being given from their territory. So one of the many casualties of the Brexit process is, of course, that we're now out of that, and the rest of the European Union haven't necessarily signed up to the Hague Convention on Evidence, which is how the rest of the world deals with it. So, you might have thought, mightn't you, that giving evidence from France or Germany would be most straightforward. In fact, possibly not. It may well be that inquiries have to be made to the FCA on an individual basis for the moment. Another thing that the NARE tribunal gives us an address, which in fact has become out of date, I believe. So in fact, the email address that should be used now is SOP inquiries. So the Home Office planning officers regularly give this out at court, so there's no secret to it. Yeah, SOP inquiries at fcdo.gov.uk. That's SOPE. I got that completely wrong. SOP inquiries, yeah, SOP inquiries at fcdo.gov.uk. You can email that source, hopefully a few days before the hearing, and you may get a reply. It certainly worked for me a couple of times recently. There's also a list that the presenting officers sometimes read out in the hearings. I haven't got the full list, but I can tell you that countries that feature on it, where the national authorities don't mind evidence being given, and so there's an automatic permission, they include, of countries we commonly deal with, Egypt, Hong Kong, India, Pakistan, Sri Lanka, Uganda, Nigeria, Jamaica. And there's others. I haven't got the full list, as I say, but they're ones that I've just noted in my own work in the last few months that presenting officers tell us that there's no objection from those countries. Another thing that you can look up for yourself is the convention, the Hague Convention on Evidence. And the Hague Convention on Evidence will tell you if a foreign state is a signatory to the Hague Convention, and whether or not the UK recognises the fact of them having signed up to the convention, and that might take you so far as well. But I think the reality is that unless you're lucky enough to know that your country is one where the national authorities are okay about it, you're going to be emailing SOP inquiries hope that they help out. Okay, so that's the as I say, surprisingly rich topic of giving evidence from abroad. The other topic I wanted to talk about, and that one was perhaps more legal content than one might have anticipated. The other point is the highly practical issue of running the remote hearing. And so for these purposes, there's a whole series of considerations, which in fact, one could easily come up with one's own list. We aim to help you in the book a bit with commonly recurring issues, but if one could just run through what a hearing is like in person and then transpose that into how it would be remotely and think about each stage. But of course, the reality has been, for the last 30 years, is that the counsel and solicitor advocates and everyone else who represents in the tribunals has been able to use the waiting time. And goodness knows there can be a bountiful supply of waiting time in the tribunal historically, and that is used for all kinds of informal advice and guidance to be given. And because they're all there together, things tend to work out for themselves. So important, but obviously remotely, nothing works itself out unless it's overtly engineered. So to start off with, there's a checklist that you could easily put together for yourself, as I say, about things that you're going to tell your client well before the hearing, and things that you're going to tell them immediately before the hearing, different categories of information. So one thing to make sure the client understands is important to log on well before the hearing starts. Probably from experience, it tends to be counsel who leaves it a bit last minute in terms of the moment of logging in. The theory is that one logs on, optimistically 30 minutes early, perhaps, more realistically 15 minutes early. But it's important to log on in really good time, because remember, the court usher is going to log on much earlier than you might interface with them in real life. And the court usher is going to, they're not going to be monitoring you constantly. So in a sense, they need to catch you, 15 or 20 minutes before the hearing in order for everything to start smoothly proceeding. Of course, for your client, probably we're all quite good at remote conferencing, probably a lot better than we were at it 18 months ago. So I'd suggest that, that you make sure that your client is au fait with it, because I tend to expect that everyone does remote conferencing a lot, but in fact, many clients don't. And so make sure that make sure firstly that they've practiced remote conferencing in theory. They'll be using CVP usually, or maybe Teams, depending on what the tribunal decides to use on the day. But obviously it doesn't matter what they practice with. They can practice with Zoom, and they can practice with their, friends, family, or neighbors, or whatever. And so then they can just work out just obvious issues about, speaking slowly. They can practice that. They can make sure that they're in a light space in their room. They can make sure that there's no blinding light source, obliterating them, as I've accidentally done a few times by sitting too directly underneath a light. All kinds of things to be looked into. To be there, practical factors. I suppose if I really dedicated to this on hourly rates, I suppose might actually hold a rehearsal of this kind of stuff with their clients, but probably easier just to do it on a checklist. Okay. Next point, is obviously, again, make sure that they, and of course you, join the hearing fully charged. Again, and don't nothing worse than running out of battery early in the hearing. It's embarrassing. Who knows? The other parties might even notice, though certainly it often goes unnoticed, a couple of minutes disappearance from a hearing. But try not to do that. Make sure that that people understand that they have to be there for the whole day, albeit that potentially, and that goes for, it's obvious for the appellant, but it goes for witnesses who may have professional or childcare responsibilities. And so make sure that they know that potentially that they have to be available all day. Of course, they don't have to be available till it starts, and often remote hearings start at 12 or 12:30 or 2. That's already an improvement from the old days. And of course, in reality, the tribunal is usually willing to take a witness out of turn, particularly a professional witness if they've got a cogent reason for being elsewhere. And the reality is that these days, most hearings tend to happen pretty speedily. Another thing to bear in mind on the witness selection point, Peter kind of made this point, but just to drum it home really, that the possibility of giving evidence remotely does open up who can join the hearing, and all kinds of characters who historically would tell us to sling our hook if we asked them to come to a hearing might now join in if they think that potentially it's a brief moment in the day, and anyway, they're working at home doing paperwork anyway. What's the problem with joining a hearing for a few minutes? So that's country experts who never get to court normally without a big fee, medical experts. It could be both physicians and psychiatrists, social workers, school teachers, all kinds of people who can make a real difference to the force of a case, but who just wouldn't have been available to us in the past. So bear that in mind, but also make sure that they remember that they are participating in a remote hearing, because again, these remote engagement can slip the mind and slip the diary. Okay. Of course, I've already dealt with giving evidence from abroad, but don't forget to have that on your checklist, because it's easy to forget these days. The classic scenario, yeah, entry clearance appeals. Entry clearance appeals always used to be sponsor only in terms of the evidence. Nowadays, one could easily expect, and some appellants and solicitors and barristers do automatically expect, the appellant to be giving evidence. Well, great if that's, if you're from India or Pakistan, one of those countries with a generic green light on giving evidence from their territory, but bear in mind it's not always so straightforward. Also bear in mind with entry clearance witnesses, and this is the main case where you have, you've got the decision to make. Do they need to give evidence? In the sense that historically they didn't, and it didn't seem to matter, given that entry clearance appeals were historically one of the most successful species of appeals, and the appellant never gave evidence, so it didn't do too much harm. But if the Home Office has refused, entry clearance officers refused, basically because of a lack of substantiation, without really making a credibility attack on the appellant, they may not need to give evidence. But the more that an individualized attack has been made, or criticism has been made of stuff that they've said in the past, then the more likely it is that them giving evidence would add value to the proceedings. Okay, another point. So something else that you might want to know, obviously, normally at the hearing, during your chatting time, your waiting, the interminable waiting time at Hatton Cross, there'd be an opportunity to talk about what kinds of things the Home Office might ask in cross-examination. Now, of course, we're not American lawyers, and we're not allowed to rehearse our witnesses, but obviously you're entitled to tell your client what to expect broadly in terms of the likely lines of questioning. Of course, now, for remote proceedings, you might choose to have a stage of the case where you email the witnesses saying, look, I'm not allowed to rehearse you on issues, but I am going to point out the common themes that the Home Office case theory implies. You're an adult dependent relative appellant. Experience tells me that the Home Office are going to examine carefully, did you research every care home in your country of origin? How often did the doctor who's written the report actually see you? All those kinds of questions, yeah. So one can predict it, and that's not illegitimate rehearsal to identify to your client the areas they'll be questioned on. Obviously, what you're not allowed to do is to practice questions and answers. Okay, then at the hearing, and again, now this is pure checklist territory, yeah. I mean, obviously the hearing happens much like traditional hearings, doesn't it? I mean, it opens out with a warning. Of course, there are some extra warnings about how you'll go to prison if you accidentally press the record button, and so don't do that. Especially given that an automatic voice will come over and cast a shadow over the hearing, saying we are now recording, and that's you in danger of being carted off to prison. So make sure that you don't accidentally hit the record button during the tribunal hearing. It shouldn't happen, obviously, if they've properly set up the CVP hearing. Usual process, of course, you can tell them that you're going to be asking any questions if you think it's appropriate. The Home Office lawyer will have cross-examination. The judge may have their questions. More important, probably on virtual hearings, to be slow, because to be honest, it's quite easy in remote hearings to drift off. And so as soon as someone starts, gabbling their evidence, there is a bit of a danger of the judge and everyone else switching off. So, clients should speak slowly in order to make sure they're heard. Pete's postage stamp theory, particularly important there. Witness, again, it's very tempting for a witness at home, in their office at home, in the lounge at home, to start looking at things which they might not, they might be supposed to they might be entitled to look at it, they might not. They're not really supposed to look at their witness statement unless they're referred to it, because it's their evidence, so why would they need to check it? Of course, they might need the bundle. Again, it's a bit embarrassing when halfway through the hearing, the question comes, I'm just referring to your bundle. And then we have the what bundle business, which just slows you down and looks embarrassing. So make sure the appellant is used to working with a PDF of the bundle and knows how to see what page they're being referred to. Make sure the witness understands that they mustn't be prompted. As Pete said, it was indeed one of my cases where the judge actually intervened. They talk about activist lawyers. I had an activist judge, who actually jumped up from his desk, ran, opened the door, chased my interpreter down the corridor, and took a serious separation of powers issue arose really about what he then did. But anyway, it was an adventure. Anyway, so don't let the client have their family proceeding through the hearing room, through their lounge. Try not to have people cooking dinner during the hearing. I've even had that when I sat as a judge once. That kind of thing. Some proprieties in order, and people need to bear that in mind. A final point, right, is that there is a temptation for the judge to let the interpreter interpret submissions in real time. Now, in in-person hearings, that would be done by the interpreter whispering at the back of the court, and it didn't hold things up. These days, and I had a presenting officer when I was sitting not long ago, and the presenting officer made 90-minute submissions, which the interpreter then explained at length. The reason it was 90 minutes, not 45 minutes, because everything was translated. And unfortunately, my hearing management wasn't quite on top of the things. It seems to me that you would be entitled, as the solicitor or the advocate, to say at the outset of the hearing, when it comes to submissions, I'm going to summarize the submissions after the hearing for my client's benefit. And so long as the client's happy with that, then that can be done. And indeed, many, many appellants have always consented to that process. It may not always be appropriate, depending on how engaged the appellant and the issues that are arising, but it can be appropriate. And if you can opt out of that live interpretation, then you can speed the hearing along no end. Okay, well, those were the points that I wanted to make on my two topics at the moment. And I think Pete's next subject matter is going to be, Pete may want to add anything he wants to say about advocacy during the hearing at this moment. And then Pete's other topic, I think, is the JCWI case. Over to you.
Yes, I'll come to that. I'll come to that afterwards. Just on the advocacy issue, there's quite a good bit we've got in our book here at paragraph 7.5, which makes the point about, as I said, whether a case can be dealt with fairly and justly. And it's the key points on oral advocacy, as is often said to be the case, that oral arguments, particularly persuasive force, which enable judges to fully understand and engage with parties' arguments, and thereby gives the parties the opportunity to identify what judges perceive as weaknesses in their case and directly address those perceived weaknesses. Now, obviously, I don't know about Mark, but certainly I remember back in the days when we used to have renewed Court of Appeal permission hearings, and one would go into the Court of Appeal and you'd be given 15 minutes to persuade the judge on an ex parte basis as to why permission should be granted, notwithstanding the paper refusal. And it was always the case that one knew whether or not you were going to get anywhere based on whether the judge actually started interfering and asking questions. There were those judges who would sit there and you could basically be telling them your recipe for spaghetti alla vongole, and they wouldn't really care so long as it was done within 15 minutes, because they were already knew what they were going to do with the decision, which was to refuse. And it's often that way with oral advocacy, that you give the chance of the judge to actually engage with the issues being asked, whether it be a witness's evidence. Sometimes, obviously, they should wait their turn to ask questions, but particularly with the legal submissions at whichever level. And one of the points about remote hearings has been a concern of this idea that judges are less keen or less interested in intervening, with the advocate's submissions. And so one of the suggestions made rather helpfully by the Administrative Law Bar Association in a paper on this is for advocates to pause more often. Now, obviously, with the wrong kind of judge, that could come across as somewhat provocative. In other words, you make a point and then pause. And the judge is not interested, doesn't want to engage, and just sort of sits there and you have a sort of standoff. But obviously one hopes that you'll always be dealing with a judge who at least is engaged with the issue and wants to make sure that the decision made is the correct one. And so there are sort of different styles of advocacy, as well as evidence taking and so forth, in remote hearings compared with live ones, which are always worth bearing in mind. So yes, that's what I wanted to talk about, advocacy, and I certainly will deal with the issue of JCW. But Mark, did you want to talk about the out-of-country deports and the effective access to justice first? And then I can wind up with something about the JCWI case, and then we could have question session.
Okay, sure. Yes, indeed. And as Pete says, I forgot to announce earlier on that we are you can ask questions. If you want to type them into the chat, you can do that, and we'll have a go at answering them, or we'll also, you can also save them up to the end. Okay. So before the era of remote hearings and the pandemic, of course, we had a distinct environment whereby out-of-country appeals were largely discussed in the context of non-suspensive appeals, i.e. appeals that have been deliberately rendered out of country by government policy on the statute book. And this has had a few old ups and downs, hasn't it? The progress of the out-of-country policy. It started off, of course, its first kind of high point was Chiari and Bindloss back in 2017, another era now in some ways. And in Chiari and Bindloss, of course, the Supreme Court looked in detail at the satisfactoriness or want of it of out-of-country appeals, and found out that on the available evidence then, there was a lot of judicial discontent with how successful remote hearings operated, about the available technology, and so forth and so on. The Supreme Court also emphasised the fact that the overriding public interest was always going to be that the appeal had to be effective, and that's still central, absolutely central to English law. One corner of the principle got cut off at the beginning of this year by the Begum case in the Supreme Court, where it was said that in a case where a witness's arrival, even the appellant's arrival in the UK, would threaten national security interests, then that wasn't something that could be litigated. And so you would have to have an indefinite stay on the proceedings until some solution was found. But that's a very specific doctrine that only applies in national security cases. Generally speaking, appeals have to be fair. And as Lord Justice Singh put it in one case, it's really very hard indeed to imagine a situation where the court or tribunal says, we cannot hold a fair trial, but we are going to go on anyway. So that's quite clear where the public interest lies. Other principles that have been identified over time in Chiari Bindloss and the subsequent round of Court of Appeal hearings afterwards were the fact that it was fundamentally wrong to let one party to an appeal weaken the other party's case. So one issue is not just how easy is it to access the hearing for you and your witnesses, but is the quality of your case going to be substantively damaged? For example, if you're going to be shut out of family law proceedings by being thrown out the country sooner rather than later, that might, of course, negate the whole appeal process by predetermining the issue. If you don't have any more family life because you lose a family case in which you're not able to give evidence in, then of course that would be a devastating collapse of fair trial. So those are the first round of sort of points of principle made. And then we have the next round of cases from the Court of Appeal like Nixon, and then tribunal cases like AJ Nigeria. And in this series of cases, the practicalities are examined in more detail. One practical theme is who does what in these procedures, because of course, potentially you've got a JR going on, a JR of was it right to remove the person pursuant to certification of their case as non-suspensive. But also you've got the tribunal appeal on foot. what is to take precedence, what is to be argued where. And increasingly, in the last 3 years, we've seen that the higher courts have encouraged the first tier tribunal to take control over things. Yeah? So it's really for the tribunal to take control of the case management and to decide whether or not the case is suitable for out-of-country appeal. Now, of course, the problem here, of course, though, is that what if your client is facing removal anyway? This has all gone quiet, hasn't it, in the pandemic era when people aren't being removed so much. But it will soon be back, no doubt, this is an issue. So you have a situation where only the higher courts can actually enforce a person's return by a mandatory order for their return. The first tier tribunal can just make observations. And in fact, increasingly, I think in AJ Nigeria has remarked that actually the tribunal might have to give a guide to the higher courts to encourage a mandatory order being made. But basically, you're looking for, I think, what Justice McCloskey once called judicial choreography, where two sets of proceedings work in tandem, hopefully, to help and not hinder each other. What are the issues that we'd be looking at then to decide whether or not a case is suitable? There's a shopping list. What the obvious mundane one is about the access to the right kind of technology and to an appropriately secure and formal setting. That might knock out some cases in limine if the appellant doesn't have access to an indoor space, which is a room of their own. That's an important issue. Then evidence collection. Do experts need to be physically present? And as will often be the case with psychiatrists, possibly with social workers who need to observe the functioning of a family unit. Physical presence will demand, that the appeal be heard in country, one imagines, or at least that the appellant be brought back in good time for those bits of evidence to be completed. A very interesting recent case, Juba, actually, for just a very recent case indeed from the Upper Tribunal, JUBA Juba, tells us that there are all kinds of intensely practical issues. And there's a really valuable piece of work done by Mr. Jones of Wilson Solicitors LLP, who sets out in great detail all the practical steps that the firm had taken to try and move things along. And again, that is a shopping list against which you could take instructions in terms of seeing what have you got the capacity to deal with, what problems might you encounter. So thank you very much, Mr. Jones, in the Juba case for doing so much work on that. The tribunal in Juba say that the test ultimately is, are you facing inconvenience in preparing your case? If so, hard luck. Or are you facing an actual impediment to putting the case together? And if there's an actual impediment, then the first tier tribunal should decline to hear the appeal. And I suppose that will be a very strong encouragement to the High Court to issue an order, or for the Home Office to curtail all this and simply give whatever they do, a visa or an entry clearance document or a laissez-passer document to secure the person's return for the duration of the appeal proceedings. Also, in Juba, they emphasise that the tribunal should keep an open mind, and it might only halfway through a hearing realise that the hearing is impractical to carry on with, because it simply, if it wasn't unfair at the start, it's become unfair halfway through. So very important, not to get too much momentum. Very tempting, obviously, once one started something to soldier on, but that's not necessarily right in the Section 94B certificate cases. Okay, that's what I wanted to say about out-of-country appeals.
Okay, thanks very much, Mark. One just other point, just based purely on my own observation of these remote hearings, is that where I think it's most difficult is actually for the party that has to cross-examine a witness. I think in terms of leading the evidence, particularly in a jurisdiction like ours, where written witness statements are provided, and therefore we don't spend too much time questioning our own witnesses, where the remote hearing becomes more difficult is actually for the Home Office in cross-examining. Obviously, some of them are better at it than others, but that's always a point worth bearing in mind sometimes when clients say they want or don't want a remote hearing. There are potential advantages to remote hearings because it makes it more difficult for a skilled cross-examiner to catch out the witness. And one sees this in practice a number of times. Now, just turning to another topic, though, which is, strictly speaking, not to do with remote hearings, it's the business of going even further, and it's making decisions on the papers. Now, at the beginning, particularly of the pandemic, the overall president of tribunals issued a practice direction, COVID-19 contingency arrangements, back in 2020. And paragraph 4 of that practice direction stated that where a chamber's procedure rules allow decisions to be made without a hearing, decisions should usually be made in this way, provided this is in accordance with the overriding objective, fairly and justly, the parties' ECHR rights, and the Chamber's procedure rules about notice and consent. So that was the practice direction issued by the overall president. Now, the upper tribunals, Immigration and Asylum Chamber procedure rules at Rule 34 do have this provision. 34.1, subject to paragraphs 2 and 3, the upper tribunal may make any decision without a hearing. 2, the upper tribunal must have regard to any view expressed by a party when deciding whether to hold a hearing to consider any matter and the form of any such hearing. And then there's 3, in immigration judicial review proceedings, the upper tribunal must hold a hearing before making a decision which disposes of proceedings, not affecting paragraph 4, strikeouts and so forth, and obviously where there's a totally without merit on a paper JR refusal. But anyway, that's the background. So Rule 34 of the upper tribunals rules provide for that particular chamber to make decisions without a hearing. So the president of the chamber issued a guidance note at the beginning of the pandemic, and in section D of that said that the guidance note concerning making certain appeal decisions without a hearing. And it said, paragraph 4 of the practice direction provides that during the pandemic, decisions should usually be made this way. But of course, it said that with those caveats. Paragraph 14 said that it is unusual for the questions of whether the first tier tribunal's decision was legally wrong and whether it should be set aside to require oral evidence and or findings of fact by the upper tribunal. But if that is the position, the judge may decide a hearing is necessary. The presence of particularly complex or novel important issues of law may also be such as to necessitate a hearing. So this is the guidance based on the practice statement. Paragraph 16 said that the fact that the outcome of the appeal is of importance to a party or another person will not, without more, constitute a reason to convene a hearing to decide the relevant questions. So that was the guidance based on the practice direction, and that was challenged by the Joint Council for the Welfare of Immigrants in a judicial review that went before Mr. Justice Fordham. Now, so what he decided in the case of JCWI against President of the Upper Tribunal 2020 EWHC 3103, and it's referenced in the book all at paragraph 4.59. So, there's it is in the book. He ruled the guidance unlawful. And the point was made that he said this is so paragraph 4 of the practice direction established a norm that appeals would normally be determined on paper. However, that norm was subject to the proviso, the one about it is making sure that ECHR rights, etc., everything. So in the language of Mr. Justice Foreman, that established a contingent paper norm, not an overall paper norm. However, the guidance based on that did communicate an overall paper norm, particularly for the what we call the error of law hearings in front of the upper tribunal. And the point was made that paragraph 9 stated by reference to paragraph 4 that decisions in substantive IAC should usually be made without a hearing. To be fair, what the upper tribunal is really concerned about is the first stage hearings where they decide whether or not the FDT decision was in error of law. And they started issuing all these directions where the general presumption was that there would not be a hearing. And they conveyed the clear message that the ordinary consideration of factual matters or legal issues would not normally be a reason for an oral hearing. So that was unlawful. The unlawfulness of the paper norm is not the case of the guidance note communication of the paper norm be unlawful, even if an overall paper norm were held to be consistent with the overriding objective. The point being is that he said that what the guidance did is that it contradicted the practice direction, and therefore it was unlawful for those reasons. And it was also wrong at paragraph 16 to say that the importance of the outcome of the case or mainstream case shouldn't be relevant to the issue. That was also wrong. So the point being is he quashed the guidance and said the guidance had been issued unlawfully. But what was the consequence of that? Because by that stage, a large number of decisions had gone out. So where someone had been granted permission to appeal to the upper tribunal, they were then receiving directions from the upper tribunal that basically put forward the proposition that there would be a paper decision made with written submissions only on the issue of whether or not there was a material error of law in the first tier tribunal's decision. It is worth pointing out, as per Rule 34.2, that in those standard directions, the tribunal did give an opportunity to the representatives of the parties, both appellant and Home Office, well, obviously the Home Office might be the appellant, but both immigrant and Home Office, to give a view on it. And the wise people amongst us always, even if agreeing to it in the sense of putting in written submissions, would argue that it was actually the wrong way of going about it. An element of the cake and eat it approach, which was that if the upper tribunal agreed that there was an error of law on the basis of the paper written submissions and then remitted the appeal, you were happy. If they didn't, you would make the point that you hadn't ever agreed to it. But according to the guidance, that wasn't the key and only issue. So the guidance was declared to be unlawful. The result of that, however, was that where in a tribunal substantive appeal had been determined without a hearing in the Secretary of State's favour, so this was an issue where if the Secretary of State had lost on the basis of a paper decision, well, that was bad luck for the Secretary of State. But where it was in the Secretary of State's favour, or where a judge had decided that the appeal would be determined without a hearing, then the President of the Tribunal would order to write to the person challenging the Secretary of State's decision, informing them of the instant judgment and advising them to seek legal advice. So the President of the Tribunal had to write to all those parties where they had lost the case on the basis of a paper decision under Rule 34, advising that they could seek advice. And one possibility, therefore, were those people could then make an application under Rule 43 of the Upper Tribunal rules, which provides as follows: setting aside a decision which disposes of proceedings. The Upper Tribunal may set aside a decision which disposes of proceedings or part of such a decision and remake the decision or the relevant part of it. So obviously where the Upper Tribunal's paper decision is that the FTT did not err in law, with the result that the appellant's appeal is dismissed, that disposes of the proceedings. And the conditions were the Upper Tribunal considered that in the interest of justice to do so, and one or more of the conditions below are satisfied: that a document relating to proceedings not sent was not received in an appropriate time, a document relating to proceedings not sent to the Upper Tribunal, a party or a party's representative was not present at a hearing related to proceedings, or there been some other procedure irregularity in the proceedings. Now, as a result of these notices going out to people, which then in a sense invited them or enabled them to make Rule 43 applications, a tribunal panel was set up in the spring with Mr. Justice Swift and Upper Tribunal Judge Blundell, who were dealing with a whole series of cases in which this had happened. And it was Mr. Della for the Home Office opposing. Now, I was involved in one of these cases at one stage, but then that fell away. Now, the last I knew is that they were going to have a hearing of these issues in the middle of June this year. And I've looked and so forth and haven't yet been able to find any decisions made. And maybe other people are much more up on the ball on this. But obviously one of the big issues there was the degree to which the process of a paper decision had been consented to versus those in which there had been an objection. Because obviously it's much easier to say that there's been a procedural irregularity in the proceedings where the appellant side, for example, has said, no, we want a full oral hearing on the issue of error of law, versus the situation where you'd either had explicit consent from the party saying, no, we're happy for the process to go on by paper, so long as we win, or an implicit one where we actually nothing is said. So these are all issues that were being considered by that panel, one assumes, back in June. And it would be interesting to know from participants whether there's been any developments on that, because certainly there hasn't been, and I think, Mark, you'd agree, there hasn't been any actual judgment on the issue, because it was certainly being considered quite difficult. In other words, it was one thing for Mr. Justice Fordham in the High Court to quash the lawfulness of the guidance. It was quite another thing for people to take, as it were, advantage. It certainly wasn't the case that there was a sort of general view that said, in whatever case you've been involved where you've lost on the papers, you can now have another run at it. It was very much based on the provisions of Rule 43 of the Upper Tribunal Procedures Rules and the relevant criteria there for unfairness, plus procedural irregularity, or to an extent possibly representatives not present. So that's something that's ongoing. And I am now told very helpfully by Kawe that the decision was handed down by the UT last week and refused 16 applications. And certainly from my limited involvement in it, it was looking that it was going to be difficult for people in those cases particularly where they hadn't objected to the process at the time, to effectively have a second go at it. Anyway, that guidance is obviously gone because it was quashed as unlawful. And now the general provision is that, you know, the tribunal will be more wary about setting up paper decisions on even the, you know, on the error of law issue, whereas you obviously can move into having a full remote hearing, or as we move on, presumably more and more live hearings. Just briefly finishing off on these issues, in the book we also deal in chapter 6 on judicial review, paragraph 636 on judicial review remote hearings. And there, of course, the issue is that the rule makes clear that you have to have a hearing. So where you have a permission renewal, it has to be dealt with by a hearing. And indeed, that's logical, isn't it? Because you've already been refused on the papers. So it would make no sense at all to have some attempt to not have a hearing for the renewal, where you're allowed to have a renewal. And there you have Fieldhouse as the main site. And then again, you'll do remote hearings in the normal way, and judges using Skype for Business, or sometimes Microsoft Teams for those kind of cases. Anyway, so those are the topics that we mainly wanted to cover. And it may well be that there are some questions or other issues raised by participants. Mark, have you anything to add on those latter points?
Well, I think actually, I think you've covered everything. I mean, I am in the queue. One of my cases we asked to be revisited in the light of in the light of the JCWI decision, but no active progression there. So very much a situation of watch this space. But as Pete says, I don't think unless people can actually point out to overt reasoning in the UT error of law decision, which they could have come back on. It's very hard to imagine that they're going to get anywhere. And it's not really the UT style to refer to cases and other materials that it wasn't referred to on paper. But always worth looking closely, I suppose, to see if there is something in the decision that you would have had something to say about had you had the chance.
Yes, well, as we've seen from our very helpful contributor, Kawe, it looks like the Upper Tribunal has indeed said exactly what you're saying, Mark, and has refused at least 16 of the applications. And presumably that will be coming out on Bailey and the Tribunal website in due course. Now, in terms of some of the questions lined up in the thing, we have from Ismaila, humanitarian protection for Afghanistan citizens opens the floodgates on Home Office refusal based upon family connection. Well, that's a very interesting point. I'm not sure it's a question, but yes, well, obviously everything now going on with Afghanistan raises all sorts of issues, because clearly what the Home Office here want to try and do is limit as much as possible Afghans, refugees and so forth coming here based on their own policies. And one of the little ironies, it seems to me, on that is that you have people, UK government officials, basically telling Afghan citizens who may have cooperated with the British forces to make their way and cross the border into Iran or Pakistan, which on the face of it would be an illegal border crossing. But apparently that's what British officials are telling people they should try and do. While at the same time, the Home Office here is obsessing, as it often is, on ways to sort of curb people coming to this country illegally. So there's a certain double standard there. It's all right to cross the border illegally into Pakistan and then try your luck with one of the resettlement programs, but don't you dare try and come further and cross on a little boat or otherwise to the UK, because otherwise we're going to not let you stay here on indefinite leave and all these other issues they're bringing up. So one wonders really how they can be saying that, when I suppose practical issues come into play. So, any other questions we can print in?
Just on Afghanistan, I suppose it's interesting, isn't it, that the country situation in Afghanistan is an unusually stark, and it would seem unforeseen even by the country experts who were giving expert evidence not too long ago, speedy and disastrous change. But that doesn't necessarily change the way that the system, the system has to process cases. There's obviously an argument that the Home Office should expedite family reunion cases, I suppose, of people in danger once there is a system in place that can process those cases in the first place. And I suppose a lot of people who might have run unsuccessful arguments based on westernization or perceived support, perceived Western sympathies, and lost based on the safety of Kabul, might be considering their position on fresh claims at the moment. So it'll be interesting to see what's happening. The FTT position, you may have seen the letter circulated via ILPA last week, is that the FTT is going to hear the appeals for the time being, which obviously would seem to put Afghan asylum seekers in a fairly strong position in terms of getting refugee status on the current state of the country evidence.
Yeah, we have a couple of other questions. So Babs asks, if the FTT granted permission against its own determination to appeal to the UT in a deport case on the basis that it failed to consider evidence of undue harshness when the appellant was in custody and the appeal subsequently dismissed by the UTJ, is it legally correct for the same UT judge who dismissed the appeal following error of law hearing to now be the same judge to determine further permission application from UT to the Court of Appeal? Can a judge admit earlier decision was wrong and over his own decision? Rarely, I think, but your professional views, please. Well, yes. I mean, in terms of deciding whether or not permission should be granted to the Court of Appeal from your decision, it's the norm in judicial review cases, for example, and particularly permission judicial review cases there and then, for the judge to make that decision. Now, obviously, in the vast majority of cases, they're going to refuse permission to appeal because their decision must have been right. In terms of the substantive merits appeal, it is quite often the case that the judge who dismissed the appeal will be the one who will also deal with the permission application to the UT. And so I would say, again, subject to what Mark thinks, there's certainly no error of law in that happening. And in many jurisdictions, it's quite a common thing for the judge who made the decision. Now, you might say, well, that's absurd, because obviously the judge having made the decision isn't then going to find his or her own decision arguably wrong. And that's true. And that's obviously why you can then renew the application to the higher court. Sometimes you'll have a situation where a judge makes a decision on a case and says that he or she is bound by a higher authority, which may or may not have been wrong, and will then grant permission to go to the court. So that might happen in very particular cases. And just as a complete by the by on that, I noticed when we were doing one of our earlier courses, the point was made by us, as per our book, that the business of new matters being raised on an appeal and the prohibition on that subject to the Home Office consenting to it was only applicable in the first tier tribunal, and the Upper Tribunal in a case called Birch said that it didn't apply to the Upper Tribunal because of the provisions in Section 81 of the Act. A later tribunal has now said that that was per incurium. It was wrong because it didn't follow a Court of Appeal judgment called Allen, which made the point that actually the Upper Tribunal could only do what the first tier could do. And in that case, they did make the point that it was possible that Allen itself was per incurium. So that's the kind of case where a judge making that decision could, in theory, grant permission to appeal against his own or her own decision. But in answer to the broad question, it's quite common for judges who've made that decision to be the ones who decide the permission application. I agree with you, Babs, it makes it somewhat nominal, but it means that you then make the application up the line to the Court of Appeal itself. From Joe, is the Refugee Convention actually incorporated in UK law? Oh, well, that's an interesting one, isn't it, Mark? Because the immigration, the UK law, the Asylum and Immigration Appeals Act from '93 makes the provision that the immigration rules can't do anything contrary to the Refugee Convention. But I think the latest decision from the Supreme Court is that the Refugee Convention is not incorporated into UK law. Mark's agreeing.
Yeah, I think that's right. It's rather complicated, isn't it? But let's not forget
it goes back and forth.
And of course, interestingly, much of the Refugee Convention is going to be incorporated into English law by the new in the current Borders Bill, which, in order to avoid the uncomfortable situation we're now in of the EU refugee regime being retained EU law, is going to put it onto the domestic statute book. But only the bits the government likes, I suppose. I suppose the answer to that is, isn't it? It's going to put in the refugee definition, but it won't necessarily put in more controversial bits like the prohibition on non-refoulement. As I think Pete was intimating there, of course, before too long, the third edition of Symes and Jorro on asylum law will be underway, but that's obviously on ice at the moment until the Borders Bill fulfills its final form. Okay, no more questions appearing so far, so maybe we're getting to winding up time.
Yeah. Just very briefly on that, I did notice that a recent tribunal decision dealing with Somalia made the point with the assertion that the qualification directive was still directly applicable in UK law, as per the party's submission. But the way they did that was really, I thought, slightly odd, because they made the point that the Withdrawal Act makes it clear that EU law provisions that were incorporated into domestic law by provisions other than the European Communities Act itself would remain valid in UK law, which is, if it's in domestic law anyway, is obvious. And then it made that the provisions of the qualification directive have been domestically incorporated in the immigration rules and the qualification regulations. And therefore, on that logic, the qualification directive is still directly applicable in the UK. But I'm not sure how that's meaningful, because obviously the reality is that the qualification regulations and the immigration rules are directly applicable in UK law. And to the extent that they copy the qualification directive Mark 1, obviously the UK never adopted the second qualification directive, revised one, then slightly stating the obvious in a somewhat pointless way, but there we are. I mean, those provisions are part of UK law because they are the immigration rules and the qualification regulations. And as Mark rightly says, aspects of the Refugee Convention will be once this new and latest bill comes into force, becomes an act.
Yeah, obviously, this is what we're seeing here. The comments made, perhaps obiter in AINTE, that's the case, in AINTE, this new serious harm case. Very scholarly case, very nice piece of writing by the Upper Tribunal. But the reason why the Upper Tribunal is driven to get into this territory of, has the qualification directive been incorporated, is it still directly effective, is because the Supreme Court said it was in G&G a few months ago, the case about Hague Convention returns. Now, obviously, the Supreme Court can't possibly be wrong, what with them being them and all that. But it's very difficult to see how that can be right. Because if, for example, if the Supreme Court in G&G are right that the qualification directive is directly effective still, then why isn't the procedures directive also directly effective still? As Pete touched on, the only possible rationale for that is that the qualification directive has been transposed into the immigration rules and also the 2006 protection regulations, whereas the procedures directive was only transposed into rules which have since been reversed. But unfortunately, it's the fault of the Supreme Court in G&G, who are now going to have everyone chasing their tails for a few months while people try and work out what they mean. One of the big questions for determination in months to come is going to be, are the immigration rules retained EU law, or is it only statutory instruments? You can already see, different possible answers to that. It seems to me the immigration rules are EU retained law whenever they reflected something that was in one of the directives. And this is particularly interesting because, of course, in free movement law, it's virtually all been repealed. And so we don't have an issue about EU retained law most of the time in free movement law, because everything was repealed, and the withdrawal agreement is the basis for future thinking. But we don't have a clean break in refugee law, where we've still got many provisions which are plainly domesticated version of EU law, living in the immigration rules and living in various instruments. Okay.
Yes, on that we have a point from Robin. Isn't non-refoulement peremptory norm or is of international, or how could they leave it out? Well, I mean, the provision on non-refoulement is, of course, incorporated into the immigration rules. I haven't got them in front of me, but the part of the definition of when you'll grant someone refugee status based on non-refoulement principles. Babs, at what stage of an immigration appeal can new evidence be introduced if it provides extant challenge to the issue affecting appellants' British citizen children's welfare? FTT, UT, COA, or Supreme Court? Well, we just seem to be moving somewhat away from remote hearings, but well, yeah, I mean, the new evidence can be, obviously, the Court of Appeal and the Supreme Court are not really fora for new evidence. That's not their role. They tend to look to the situation as it was, the evidence that was before the court that they're determining the appeal from. In the FDT, new evidence can certainly be put in, subject always to this Section 85 business of new matters. And it's always worth pointing out when it comes to new matters. And then in the upper tribunal, it would be admissible as per that Section 85, the non-Birch approach, if they're rehearing the case. And it's always worth pointing out that the Home Office's own guidance on new matters is that the general presumption should be to allow the new matter to go before the tribunal rather than not to do so. So there's a lot of case law that makes points like, for example, if a child is born to a couple that changes the nature of their Appendix FM validity of immigration application, that's a new matter. But, and unless it's really the case that the Home Office are simply on effectively scrounging for money, in other words, you have to make a new expensive application, they would normally allow that in before the first tier substantive hearing, or the upper tier if it was a second stage hearing. Mark, do you agree with that?
Yeah, definitely. I mean, it is rather left. The current system rather leaves it to the common sense of the Home Office, who have they can turn on and off the tap on fresh evidence by giving consent. It is interesting how the Home Office guidance strongly indicates that they will be giving consent unless they really can't. Whereas the impression one gets from one's own practice is that consent is not readily given if it can possibly be withheld. There is a tension there. And I think the Upper Tribunal's response to that point was that, oh, well, you can JR them if they act inconsistently with policy. But I mean, privately, these will often be privately paid.
Yeah.
I mean, the litigation appetite, the risk appetite is just not going to be there for satellite litigation most of the time, and for good or bad.
No, I mean, the only basis in which the Home Office would say we don't consent to this is that we want to put you through the mill of making another application. Because if they consider that the new matter is one that's not going to knock out their decision, in other words, yes, judge, you consider it and still dismiss the appeal, then query why they wouldn't want to give consent, because after all, the old one-stop procedure, that was directed specifically at trying to stop people making subsequent, consecutive, new application. So one would have to think slightly that why would you not consent unless you thought that this new matter, new evidence, was going to sway the judge into allowing an appeal that might otherwise be dismissed? And if that's right, then it does call into question what the purpose of not allowing the new evidence in. But as Mark rightly says, the courts tend to take a view that, well, that's a matter for the Home Office, and if it really is a matter of them making someone make a new application at great expense, then I suppose a judicial review, which of course then brings its own issues of expense to play. Okay, well, that looks like nearly all the questions dealt with, and it is coming up to 20 past. So we hope that you've either all bought the book or will buy it. Right way back. And we hope that it's useful. As I say, at least one bit of it's already now wrong, because the Birch thing is mentioned in a few footnotes and it's now been reversed, but it's all there on Bailey. Yeah, so I think we'll say goodbye. Okay, thanks for everyone for coming, and I hope you found those of you who attended all 3 sessions useful and not too long-winded. And thanks very much, and hope to see you, in court soon and all the rest of it, some of you. Okay then, bye-bye from me.